Hello, friends and family, and welcome to another episode of the Purple Couch Podcast. Today's episode is pretty important. It's all about knowing your rights as a caregiver and specifically for your child. Advocating for your child is something that we take very important. And today we brought a special guest, attorney David Slonim, who brings to us 20 plus years of experience helping families across Florida. So sit back and enjoy this episode of the Purple Couch Podcast.
Welcome to Pam and the Purple Couch Podcast, hosted by Pamela Furr, with our co-hosts, Dr. Manny Rodriguez, Missy Owen, and Loki DePristo. Together, we're going to dive deep into topics such as education, neurodiversity, autism, and applied behavioral analysis. Remember to click subscribe today so you don't miss out on any future episodes.
Hi, friends and family, and welcome back to another episode of Pam and the Purple Couch Podcast. So, today on the couch, I am very elated to talk to my friend and a friend of our families. And when I say families, I mean our puzzle box families. So, David Slonim of Slonim Law here in Melbourne, Florida, like Manny had said, 20 years experience, and he's bringing it to the couch today. Why? Because we want to talk about advocating for our kids' rights. And what does that mean? Well, what do you do when your kid starts aging out of the system? What happens when grandma and grandpa come into the situation and they have to help mom and dad and may have to take over some of those responsibilities to help the family survive? Well, in this economy and in this world today, we're seeing it happen more and more. So today, please welcome my friend, David. David, hi.
Hi,
to the
Pam.
podcast.
Thanks.
How are you?
Thanks for having me. Good.
Absolutely.
Good.
So we're really relaxed here on the couch. We kind of go with the flow. We do it like from my couch to my family's couches. So please relax and enjoy the conversation. And at any time, I'm a jabberjaws. You can be like, okay, Pam, we need to make sure. And just if there's a key point, target it right to our families because we want to make sure that information that's not readily available in Wisconsin, in Minnesota, in Michigan, in West Bygod, Virginia, my hometown, they don't have resources like this because a lot of times they're just trying to figure out where ABC is right now because they have a child that's either non-speaking, non-verbal, and when I say non-speaking, because it doesn't mean they're not expressing themselves, or their parents are at loss. They don't know where to go. They don't know what to do. And so they're in crisis a lot of times. Our families are in crisis. So they're just trying to go one day at a time. What we're talking about now is when that 15, 16-year-old, when we start to think about, oh my goodness, what do I do when Johnny turns 18 or 19? Loki, who's on our podcast, I'm going to use as the prime example. He's 19 now with his associates in psychology, but he has the mentality in common sense world of a 16, 17-year-old.
Right.
So I know when you've talked to our family, some of the things that I bring up in those sessions are the outliers, not the typical like guardianship that you would think in a normal setting that, okay, well, we've got little Betty here and Betty can't speak or Betty's not going to be able to live independently. We also need to think about guardianship for our high-functioning children because a year ago, Loki was 18, and if he would have gotten a credit card offer, which he did, Mom just put them in the Chapter 13 trash can, they could get themselves into a lot of trouble, and that ruins their credit for the rest of their lives because they're not in a place where they can financially be responsible, but yet they're 18 and still getting these wonderful offers. Example number 2, we've got some of our families that grandma and grandpa have come into the picture to facilitate taking care of little Johnny or little Betty or little Susie. And then what happens is all of a sudden the parent shows back up, which is wonderful, but that structure and consistency can all fall to the wayside. And we see it all the time. I wish we didn't, but at least one family a year, I see this tragedy happen to the child, at least. And so when we're seeing even one kid within our environment, and this is happening, I think it's really crucial that we allow our families to know what do their rights look like. And when I say rights, meaning that grandma, grandpa, let's say for 5 years you've been taking care of Susie. We haven't seen mom, we haven't seen dad, but then all of a sudden, year 7, mom shows back up. And everything that you've built, all the consistency in the structure. She could take Johnny or Sally and off they go. Because grandma and granddad, at least here in Florida, do not have any rights unless they've established them. So can you help our families with a little bit of information on, and I know I threw a lot at you, with what's the first step? Communication for us has always been just communicating. But I would like from your aspect in 20 years of, if you could talk to a family from day one and set them up in the ABC perfect world, what would a family do if grandma or grandpa is coming in and they're helping or taking care of that grandchild?
Pam, that is a lot. And so first, what I have to do is just have a disclaimer as an attorney is that I am only licensed to practice in Florida. So whatever we're talking about is going to be based on Florida law. And if there's questions that you may have that are outside of the state of Florida, then definitely go see counsel in your state. And so what we're going to talk about is kind of based on that. There'll be general kind of guidelines that may work in other states as well. But whatever I'm talking about is from my experience in Florida. And then outside of that, you're kind of to talk to your own counsel on that. So now that disclaimer's out of the way, right? So yeah, there was a judge one time that said that, when you ask an attorney just for their name, expect, 5 minutes worth of other disclaimers and discussion even before you get beyond that. So here
That's
we
a good
are.
attorney, though.
Maybe. Depends what 2 + 2 is too, right? So coming back to kind of caring for kids and family members that have developmental disabilities or other special needs, there's kind of a lot of things beyond just guardianship to do, but that's going to be also kind of one of the main issues that we're going to have to cover. So first off, let's cover what a developmental disability is also, and then kind of go beyond that and talk about what guardianship is, kind of what the other pieces of the puzzle are, so to speak.
I like that.
So first, developmental disability is something that typically starts from birth and then goes beyond to for a lifetime situation there. And that's going to be generally on the legal side going to be covered by an IEP or which is a school
Yes.
kind of a school mandated plan. And also if there isn't that, that's not available, then a doctor's kind of review is going to be important for that. So those are the kind
our
of things
families,
there.
the IEP, Individualized Education Plan. We all on this podcast, we have beaten that one up because that's the number one contract that a lot of our families need right from the beginning. If you know there's a delay, and that's in the public school system and before public school, if you're in a preschool, and depending on your state, there are 14 states in the United States that actually look at the VPK, voluntary preschool program. Even in those programs, you can ask for an assessment to be done on your child. And that's as early as 3. And again, 14 states in the United States that do recognize the VPK program. So that IEP could be one of the triggers that you're looking for, because that, again, is the education system that is acknowledging that there is a developmental delay. Now, at the same time, remember there's 504 plans too, and we don't want to get those two confused between an advanced gifted student. And I hate that because a lot of our neurodivergent kids that are listed as developmentally delayed are also superheroes. So I just want to put that out there before we proceed. So yes, the IEP, or I would assume a diagnosis from like a developmental pediatrician,
Correct.
psychologist,
Right.
that is stating that this is a lifelong situation. And in ours, David, just so you know, we've had some nurses come back and go, oh, your son or your daughter all of a sudden is not autistic. And we're like, well, great, show us that, because we're going to make $1 million here. You found the cure to autism. Parents, remember, once the diagnosis is there, then the precursors or those symptoms, they may dissipate, but that diagnosis stays with that child. So that's key importance for you all there.
Generally good, for better than worse,
Yes.
really. Actually, it opens a lot of doors when that diagnosis is in place there. And so with a guardianship, we're talking specifically when we're talking about developmental disability as a guardian advocate. There's a lot of different kinds of guardianship that are out there. There's guardian of the person, of the property, of the minor. But what we're talking about specifically here is a guardian advocate situation where there's an individual that is going to request from the court that they're going to become a person's guardian. And that person is going to be somebody with a developmental disability who is not quite 18 yet. Usually we file this when they're about 6 months away, about 17 and a half. And then it is going to be also something that is kind of special in the guardianship world where there is not a determination of incapacity. And so there is still going to be an attorney that's going to be appointed by the court. There's not going to be an examining committee like there would be in other guardianships. And it's something that is also special in that parents can, in Florida at least, don't necessarily have to hire an attorney to do a guardian advocate situation, but I strongly recommend it, for a lot of
I was going to say, for everything that we've been through here on the couch, parents, just like ABA, speech, OT, we want professionals dealing with our children. When you're looking at guardianship, even as someone advocating for the child, trust the professionals in that aspect and make sure that you get legal advice from counsel so that you're covered. I appreciate the fact that you're sharing this information with our families that they can do it, but go find some support.
Right.
This is your child. This is your loved one. And so we want to make sure that it's done correctly.
Yeah. And even so, every time the judge is going to change on the bench to do this, there's going to be different rules that they're going to apply beyond just the statutory guidelines. So it's always important to have some professionals involved who are familiar with those particular judges and whatnot.
Earlier you mentioned 17 and a half. But you mentioned without an incapacitation. Is there a difference if you are a caregiver of somebody that the child does not have an incapacitation versus has some type of incapacitation?
So a guardian advocate, just by nature of that type of guardianship, does not necessarily come with a determination of incapacity. There's other kinds of guardianships that do have a mental health component where the judge is going to have an order determining incapacity. And that requires an examining committee to get involved in all these other things. So it really it's kind of a more streamlined guardianship for this kind of situation there. We can do that. Yeah. And so,
function. I love that because when you were tuning in to, oh my gosh, being incapacitated, I'm going, we do have some children on the spectrum there that do fall into that. But a lot of our children, when we're talking about autism spectrum disorder, this is where that shade of gray is. And most parents don't think about this. Medical exams. This is a key one that a lot of our parents forget about is that as soon as your child turns 18, medically, without having any legal enforcement, if Missy was my daughter and she's 19 and she's having problems that need to be expressed, the doctor, without her permission, cannot share with me. Psychologically, I can tell you because my friend who is a neuropsych has been in this situation where the parent brought a child in to see her. She's given advice. And then the parent wanted to know what was going on in the meeting. She's like, I can't.
It's not even just that. A lot of parents need insurance for the kids. And a lot of insurance companies won't do anything to assist if the kid is over 18 and then there isn't a guardianship in place. So you need to make sure that these are going to be in place. And so you need those letters and orders of guardianship to kind of ensure that there's going to be continuity. So,
and I do... I do have a quick question.
Sure.
Are there any diagnoses that exist that pretty much when the kiddo turns 18, it would be an automatic guardianship?
There's no automatic guardianship.
Okay, so no matter what, you have to...
Yeah, you always have to petition the court. And so what you can do is you can create certain documents that are going to create a rebuttable presumption of who you want to be a person's guardian. So you can do that in your will or in your own documents. We have something called a pre-need guardianship declaration that allows for you to create that kind of rebuttable presumption for that.
That's very important, guys. I just said need to. There is no guarantee of guardianship. That is very important for moms, dads, grandma, grandpa. If you're sitting back and you're listening to this episode and you hear that, you may automatically assume that because your caregiving loved one is low functioning, and when I say that, meaning that they are relying on you, 100% dependent on you, that how could this person be expected to make these decisions on their own? And we need to understand that legally, as much as we don't want our children to be numbers in the government system, they are. And we all have the same rights and we all have the same roles and responsibilities unless we advocate. So that's why I'm saying, please seek out legal counsel. If it's not with David, please reach out to someone locally there within your state, within your district, so that you can get guidance.
Mm-hmm. Yeah.
I'm curious too. I mean, I remember, we were honored with you to present to our families last year, and kind of in a small group forum. And one of the things that I reflect on that presentation was the challenges, the challenges that come with trying to seek guardianship. I'm wondering if for our viewers, if you could like hint at or highlight what are some of the more common challenges that come with pursuing guardianship or advocacy, so that our families can kind of wrap their heads around some of the more common challenges that they may face when they're pursuing this.
Manny, when you're talking about that, there's a pretty wide spectrum of challenges that are going to come along with that. I think, laying it from the beginning, financial is one thing also, but understanding that kind of where the family is, where the parents are as well, is really important. So, part of this is not just looking at a guardianship for the child, but also having the parents do their own estate planning, for example, to make sure that in the event that they die, that there's going to be kind of that support system in place. So it's not just guardianship, but I really look at it as a kind of a wider spectrum of needs that need to get addressed from a more holistic perspective, legally holistic, so to speak.
Absolutely.
So it's kind of their own estate planning needs to get done. Then maybe a supplemental needs trust, also known as a special needs trust, potentially would be set up as part of that component. And we can have a separate other discussion on trusts, which I don't know if we're going to necessarily cover today. But that's a really important part of that. And then, of course, then setting up the guardianship as well. And the costs for this are sometimes prohibitive for a lot of parents or grandparents or whatever the need is going to be. And so there are some organizations that are able to support that. I can't speak to the costs necessarily, because that's kind of variable, but it's not inexpensive. Okay. And so that's something that really needs to kind of be addressed as one of the major stumbling blocks there. Sometimes the issue is family dynamics. So we're dealing with one particular case right now where we have an individual that we thought was going to be kind of fairly straightforward as to who's going to be the guardian. And now there's other family members that are coming out, and we went from a potential 15-minute hearing situation to a half-day situation that's going to be quite contested between other family members.
But aren't you glad you're in this now?
Well, yeah.
Because what David is talking about when we're looking at the holistic package of making sure that you are established and set up if something happens. And I know that's the big if. But today, we see a lot of grandparents, grandmothers, grandfathers that are coming in that are now the caregivers of their grandchildren. And so I know there was something you had mentioned. There's a resource that helps grandparents.
Sure. In Brevard, there's an organization called Grandparents Raising Grandchildren. And so they are very instrumental in supporting kind of grandparents who are not just necessarily raising the grandchildren directly, but also maybe kind of tangentially involved, where the parents kind of can flow in and out or phase in and out of a situation there. So GRG, or Grandparents Raising Grandchildren, can actually have some support, sometimes financial, sometimes other resources.
So Brevard families, I want to stop right there. We're going to put a little ching grandparents
there,
raising Grandchildren.
Yep.
Grandparents raising grandchildren
up.
here in Brevard County is a wonderful resource to go out to. Number one, meet like-minded people. The reason that they're helping other grandparents is that you're not alone. And number two, another aspect is that we never want anything bad to happen. But now we need to make sure that if something happens, that our children are prepared when we're gone. And a lot of our children can't make those decisions and they can't set up these things because they're dependent on us. And you may, just like David said in the situation he has right now, you may automatically in your head think, for me, it would be like, okay, so I know if anything happens, my sister's going to take care of Loki and everything will be okay. Well, what happens when you have two sisters or three sisters and one sister says, well, I can do a better job than this sister can.
Mm-hmm.
And now that's where David's at in a situation where it could have been a 15-minute hearing. And now it's like, well, we're going to challenge this. And I want. And you never would have thought about these things.
Mm-hmm.
And imagine that this then would have been a battle that your child is now in limbo while the courts have to make these decisions. And you never want the court to make that decision.
Yeah. And so that's why you're doing these documents. And part of the other part of the documents or of the guardianship is something called a standby guardian. And so you can kind of nominate for the court's review kind of who you would want in the event that you're not able to be the guardian. Then you're creating, again, a rebuttable presumption and kind of pre-qualifying an individual to be the next guardian if you're not able to do that for whatever reason. So you can name standby guardians to do that, and that's usually helpful. It doesn't guarantee anything,
Right.
but it's still certainly something that's going to be kind of part of kind of the plan. And again, this is where having an attorney involved, having legal counsel that kind of knows the next steps, because nobody's going to tell you these things or what you can waive or what you cannot unless you have counsel involved there.
Yeah.
So I was going to say, you ready?
Oh, yeah.
Like, subscribe,
And follow.
comment,
Oh,
comment.
Did the wrong
info.
ones.
We got it. We're trying, David. You got to laugh. We're not big publicity people. We're not promoters. We're not commercials, things like that. But our producer, and his wonderful glory, wants us to be out here in front of as many parents, caregivers as possible. So you know what that means. This is that time. If you are finding this content usable, and if you know a friend that needs this, hit that like button in the bottom corner, hit subscribe, and share. And as always, if you have questions, you can send those individual questions into info@PamelaFur.com. All right. I did it.
I know, we got it. I do have another question. Does the child ever get to give their input in the guardianship cases, or is it assumed because they need a guardianship that essentially their opinion doesn't count?
Sure. So in Florida, you can have the child involved in certain circumstances. And so if they're over 14, then the judge could ask for their input there. And so
cool.
I recently had a case where it was two kids, in fact. And so one kid was over 14, and the judge said, do you have anything you want to add to this thing? And so you can have that as part of the dynamic in the hearing, but it's not required. They can be waived, or there's some other questions on that sometimes. But it's possible to have their input there. Yeah.
And earlier you were mentioning about evaluations. So a lot of our families are in our schools, for example, the kids are pretty young. They're not 14, 15 for the most part, except for our high school. But our early kiddos, our young kiddos, 3 to 6, 3 to 9, and the families have undergone maybe 1 or 2 evaluations, right? But when it comes to advocacy and guardianship, what is do the parents have to anticipate having a new evaluation done at a certain point during that process, or is it part of the process to get an evaluation?
So there's a couple answers to that, okay? And so first, you want the most recent evaluation that can be done. So we're going to look for something within the last year, preferably. Then once the guardianship is in place, then one of the things that we have to file with the court every year is called an annual plan. And so the plan is looking forward generally on what's going to be done. So it's kind of a social plan. It's going to be kind of when you're going to go to the doctor, those sorts of things. And we also usually need a medical evaluation that's done as part of that plan to show that things are kind of still good. And so we do need to have that done annually as part of the guardianship. And the guardianship is going to last longer than you may sometimes. And so that's kind of important to kind of keep going with that.
Yeah.
Was the age.
Mm-hmm.
If we're looking, and this, I think, where David talked about the holistic package, it's not just the guardianship, it's having your estate planning also prepared. Why? Because at 5 or 6, we're not thinking about credit card debt. We're not thinking about financial obligations. We're not thinking about medical. What we should be thinking about is, and I know it's horrible, guys, and then, I'm a manifester, so I don't want to manifest anything negative, but we have to be prepared. And so what happens, and, here at work, what do we talk about? Well, what if you got hit by a bus?
Yeah.
Did you have the notes or the email to cover so that we could fill in if something happened to you? Same thing when you're talking about our families, 5, 6 years old, that are in the thick of it right now.
Well, most of the time you don't go to an attorney because everything is going great. Yeah. But some of the time you do. And that's where people come to me for the planning. Okay. So, I like to say failing to plan is planning to fail. And so, when you're actually going to be doing this, then you're going to be planning for the future. And we're kind of planning sometimes for the worst case scenarios, but we're all going to die, for example. And so, that's going to be an important aspect to consider the mortality and also some of the other challenges that we have in life. So having the guardianship is in place is important. I've had some families come to me who the kids are already in their 30s and they say, well, what can I do to kind of get things going now? And there are processes for that. It's we can still do a guardianship, but that's more going to be of a more adult style guardianship at that point. But it's also going to be important when a power of attorney isn't going to be kind of good enough. And so, once they're past the 18 kind of mark, then they're an adult. And so then it's a question as to what sort of executive function we're still going to be able to address. And so that's where the healthcare surrogate and the power of attorney are really important. Potentially that could be an avenue of progressing, but just depends on the individual. And so usually the guardianship is a little more powerful than some of these advanced directives like a power of attorney, healthcare surrogate, because a guardianship takes rights away usually.
Gotcha.
And so a power of attorney only allows you to act on the person's behalf. And so, you can say, oh, I'll just have my kid be able to sign a power of attorney and I can, or a healthcare surrogate, and I can go to the doctor, I can do all these things. But what happens if they decide all of a sudden that they're going to, meet this barista at their local, Starbucks, and all of a sudden they're in love and they're going to, go somewhere else. Okay. And then, what can you do to prevent that? A power of attorney is not going to be the tool for that. A guardianship is going to be where you need to have that kind of maintenance of control over some of these situations, because while they may be high functioning, as Pam mentioned earlier, sometimes that executive function is going to be a lower age and kind of lower intelligence and emotional quotients there. And so you're really important to have kind of a good balance. And unfortunately, sometimes a guardianship is the only way to really address that fully. So, that's kind of where we're it's important to, again, talk to legal counsel, talk to your doctor about all that there.
So, David, you're here locally in Brevard County, but you do service Florida.
Right. So we're good for all of Florida.
Tell our audience
there.
How to reach out to your office, because just like right now when you're hearing David speak, this is the passion that he handles all of the cases we send over to him. He wants to look at the entire estate planning, look at the entire situation and take it at a holistic approach, just like we do here. We look at the whole child and looking at that whole package, the whole environment to make sure that you're covered and protected, because this is an individualized plan. Your plan is not going to be the same plan as Johnny down the road. So make sure that you have legal expertise in your state that can give you the best advice, just like David here on the couch. So can you give our friends and family your information so they can reach out?
Sure. Okay, so you can find my office at slonimlaw.com. That's SLONIMLAW.com. And I'm David Slonim again. And you can reach us in Brevard or anywhere in Florida, 321-757-5701. And that's pretty good, I think. Yeah.
So falling in love, we never know when it's going to happen. We don't know if it's today, if it's tomorrow, if it's online or not. We want to make sure that you don't get the love crazies in your house and you make sure your child's protected. We've all experienced that. And love makes you do crazy things. So make sure that your loved one is protected and they don't get caught by Cupid's bow. So guys, if you've enjoyed this, come on back next time to Pam and the Purple Couch Podcast. Next time, we'll see you then.